All right, hello. I greet you in the love and the light of the one infinite creator. We're getting back into this book. It's the last chapter, or the addendum. What happens if I follow this advice and things go wrong and I fool it up? What a funny word. All right, if you guys haven't checked out the other chapters, go back and listen to the other readings of this ebook. I'll leave the place you can find the ebook in the description below. Also, I'll leave the link for Scribd, which is the app where I found the document somebody posted. So, like always, please leave a comment. If you haven't yet, please subscribe, and we'll get to it. Ready? Let's go.
Addendum. What happens if I follow this advice and things go wrong and I foul it up? If you've never been to court and actually had to defend yourself in front of a judge, actually an administrative magistrate if in traffic court, otherwise known as an attorney in black robe, it is likely that you can and will be tricked into believing what the judge says when he rules against you, denying your attempt to enter exculpatory evidence into the case or overruling any objections you may make. If you allow yourself to slip up for even 1 second and you fail to deny, object, or rebut what the judge is asserting and you accept go along with anything that he is saying, you may put yourself in danger of consenting to his jurisdiction. Despite what appears to be happening in the court, the only way that things can go wrong is if you don't stick to your guns and maintain your position, and you become bamboozled by the sophistry and lies of the government actors by believing what they are telling you is true. They will make it seem as though you are being railroaded by the system, that you have no rights, no recourse, and that the Constitution, should you, in your misguided state of mind, happen to bring it up, has no place in his courtroom, which is true, because his administrative court is based on contract law, and thus outside of constitutional parameters. If anything like this ever happens to you and you are in an administrative court of no record, you can safely disregard anything that is happening on the stage of this court as long as you don't show any sign of consent to the proceedings. The correct attitude you should take, if you want to prevail, is one of a belligerent claimant. Occasionally, judges have provided rulings that hint at the proper stance that one should take in the instance that no crime or damaging infraction has occurred. Such is the case of Federal Judge James Alger Fee. In U.S. v. Johnson, 76 Fed. Sup. 538, Federal District Court Judge James Fee ruled that the privilege against self-incrimination is neither accorded to the passive resistant, not to the person who is ignorant of his rights, nor to one who is indifferent thereto. It is a fighting clause. Its benefits can be retained only by sustained combat. It cannot be claimed by an attorney or solicitor. It is valid only when insisted upon by a belligerent claimant in person. In this ruling, the judge has just instructed you how to proceed. He has said that rights are not accorded the passive resistant. Rights are not available to the individual who is ignorant of his rights. Nor are rights available to a person who is indifferent, or in other words, a person who simply does not care. And further, Judge Fee has clearly informed you that an attorney cannot claim your rights for you, which is another way of saying that an attorney cannot truly represent you. He then tells you that rights are only available to a belligerent claimant in person. He further states that to claim your rights in a court of this country, you must be willing to engage in sustained combat. Well, that's one perspective. And a fairly sobering and straightforward one at that, should one wish to fight a traffic matter out in court. But what if you could avoid having to go to court altogether? What if? The following are a few hypothetical scenarios for you to test yourself on to see how well you have understood the concepts presented in this book. Those who might harbor some doubt about the validity of the concepts discussed here may wish to pursue additional resources as well as anecdotal evidence from others who have themselves successfully navigated through confrontations with the legal system. We say anecdotal evidence because you will not find many, if any at all, case histories where sovereign individuals have prevailed over against fictional government actors, as their cases, for the most part, have become dismissed. And therefore these cases have never been entered into the case histories, meaning you cannot look them up in order to learn from them. Would you know how to handle the following 5 scenarios? Hint: the answer to each of these legal questions has already been provided in the material above, if you have been paying attention. 1. After having been stopped for a victimless traffic violation and consenting to showing your license and registration, you are handed a citation, which you signed without reserving your rights, which asks that you present yourself in an appearance before a municipal court. Do you know how to handle this situation without having to go to court? 2. After having been stopped for a victimless traffic violation and conditionally shown your license and registration, conditionally, meaning that you have stated that the license is not for identification purposes, but only for operational competence, you are handed a citation, which you signed with a reservation of your rights, which asks that you present yourself in an appearance before a municipal court. In this situation, you were not aware that you could refuse for cause the citation and return it to its presenter, and therefore did not perform that action. Do you know how to handle this situation without having to go to court? 3. You are stopped for an expired license plate tag and are handed a citation which you signed without reserving your rights, which asks that you present yourself in an appearance before a municipal court. Instead of refusing for cause the citation and properly serving it back to its presenter, the officer, you end up having to enter the court and defend yourself. In the intervening weeks before you are scheduled for court, you obtain the proper license plate tags, thinking that you can use that as a defense. You enter the court and do not plead to the offense, but show that you now have valid license tags. The judge disregards your testimony, the fact of which, i.e., consenting to testify, admits you into his jurisdiction, enters a plea of guilty for you, and issues you a fine in the form of an order of the court. Would you know how to handle this situation in such a way that you left the courtroom, and the situation itself, without having owed or paid any fine? 4. You are stopped for a victimless traffic violation and conditionally show your license, registration, and proof of insurance. In addition to the victimless traffic violation, the officer notices that your insurance has expired. He issues you a citation for the violation and the expired insurance proof. You sign the citation with a reservation of your rights. Do you know how to handle this situation without having to go to court at the appointed date? 5. You are stopped for an expired license plate tag, and in the ensuing meeting the officer learns that your driver license is also expired, and so is your proof of insurance. He issues you a citation for each of the 3 violations. You sign the citation with a reservation of your rights. Later that same day, you take a photocopy of your refusal for cause of the citation along with obtaining a certificate of mailing, and return the refused citation to its presenter, having obtained his official mailing address. The first week goes by and you are anxious about whether or not the citation has been entered onto the court's docket, so you call the court to inquire about the citation, giving only the citation number to identify it. The clerk puts you on hold to check to see if the ticket has shown up on the docket, but it hasn't. The clerk returns asking for more information that she can use to identify the citation. In the course of your conversation, you forget about the injunction against mentioning your name, first and last, when asked by the court clerk, and you let your last name slip. Suddenly, the clerk spots the citation and mentions that she is entering it onto the docket as you speak. You mention to the clerk that the citation has been refused for cause, but she doesn't acknowledge what that signifies. So you say you will be down to file some papers into the case and hang up. The next day, you travel to the courthouse to give the clerk your photocopy of the refusal for cause, along with the original certificate of mailing. but the clerk refuses to accept the papers to file into the case, saying that you need to present these to the judge in person on the scheduled day for your appearance. At this point, there is something that you can do which will put an end to this, but let's say, for the sake of a learning experience, that you don't figure that out and do nothing, thinking that you will present the papers at the court hearing. At the court hearing, a name is called that is similar to yours and you answer by stating that you are your first and middle name only, and that you are here to take care of this matter. The judge is unfazed and motions for you to step forward into the bar. You realize that by doing so, you can be seen to be entering into his jurisdiction, so you hesitate, stating that you do not consent to entering his jurisdiction. The judge motions to the court officer to escort you to the bar, and reluctantly, under protest, you allow him to do so. You are doing everything you can think of not to consent to the jurisdiction. But you are unsure about what you are doing and what effect it is having. At one point you make a statement that you are only here to challenge jurisdiction. And since the information you read about this tells you to stand mute after having made your statement, that is exactly what you do. In a key moment of the hearing, the judge makes a statement about his courts having jurisdiction over such cases, and you neglect to object, not really sure how to handle this situation, having been instructed to remain silent after having handed over your refusal for cause. At this point, it is very easy to become caught in the net of the judge's snare if you are not familiar with court procedure and what you can and cannot do to get your position on the record. The judge proceeds to issue 3 orders of the court to handle your seeming incompetence before him. A determination of release conditions and release order ordering a trial date, bypassing the preliminary hearing and pretrial stages. An order regarding counsel appointing you an attorney to handle this case, in the interest of justice. And a notice to defendant stating that defendant must not contact the court-appointed attorney before a certain date, and giving the name and address of the attorney being appointed. On this last document, it states, you have an obligation to remain in contact with the court, as to your address and telephone number, and your attorney during the pendency of this case. If you fail to appear for any scheduled court appearance, a complaint and warrant may be issued. All this sounds awfully scary and final, doesn't it? If you didn't know what you were doing, you might accidentally make a mistake and venture into the court's jurisdiction. But since you've read this book, you should know, for the most part, how to handle this scenario in order to prevail. So, what would you do? If you are having trouble answering any of these questions, perhaps you didn't read the material closely enough. Would you like to find out? How to handle scenario 1 above by disqualifying the citation without having reserved your rights on the citation. How to handle scenario 2 above, and avoid going to court by disqualifying the citation that you signed with a reservation of rights but did not follow up with returning the citation to its presenter, refused for cause. How to handle scenario number 3 above in such a way as to not become obligated for a fine. How to handle scenario number 4 above in such a way that allows you to avoid going to court altogether. How to handle scenario number 5 above, and learn how to disqualify the court orders, including the order for a trial, in order to avoid having to go to court altogether and make it stick. This one can be a little tricky, but it can be done if you understand your rights and how to assert them and stick by them. What you can do and or say in court to extricate yourself from a situation where your identity is being stolen and assassinated by the system. Go to beattraffictickets.org and learn how to apply the concepts you have learned here as they relate to a real-life scenario. If you don't know what you are up against when faced with taking decisions in real time, you might slip up and inadvertently enter the statutory jurisdiction. And then everything you thought you learned would have been for naught. Don't take that chance. For instance, after having read this book and having followed the refused for cause procedure, would you know? How to disqualify orders of a court of no record. How to disqualify a court order setting trial date. How to disqualify a court order appointing counsel. How to avoid having to go to court altogether. If you're not sure how to effectively respond to these scenarios, you need to obtain our follow-up ebook, How to Handle the 5 Scenarios, an explanation of the concepts behind the refused for cause process. You can find this ebook at beattraffictickets.org. If you need help in creating identification documentation and/or in declaring your truth and serving lawful notice on authorities of your identity, including a discussion of key concepts that ought to be included in your affidavit and why, in addition to an example affidavit that you can use, as well as how to compose and record your declaration of truth notice and affidavit of identity, click on the link to find out more. Here are some further reference resources, in PDF format, which you can download and read to help corroborate and expand on the information given in this book. These pieces will be well worth your time to read, especially the documents on consent and presumption. Even if you don't read any of the others, make sure you read those too. You must understand these 2 concepts thoroughly if you want to have the shadow of a chance of prevailing.
All right, so that's the end of common law remedies to beat traffic tickets. Putting the law on your side. I learned a lot putting that together. I'm going to go through the chapters again in the future, probably put some videos on, breaking everything down, learning some more. So I hope you guys enjoyed learning all this great information. I hope you guys like this video. Leave a comment. Please subscribe to the channel if you want more freedom information. You want to learn how to become more of a free man in this world of contracts and laws and government's evil takeover of your body. We can get more into that later. And I thank you guys once again, and I will leave you in the love and the light of the one infinite creator. Peace.